made best efforts to alert the court of this condition that you set forth and the circumstances, but the court takes issue with that representation. The only thing you told me at the bench the last time we were in court that you had a court date in April that you needed to be at. And you told me the reason why, and I said that we would not have court those days, that I would excuse you to be to that court appearance. And that is all that you said to me. And you otherwise represented to me that once you got assistance, which the court has provided in means of funding, if necessary, for experts and investigators, that you would be ready for this trial. So while I am going to ultimately grant your motion to withdraw, because I think the way it is presented, there is no way not to, it is not accurate what you put in here.
Judge, did you want me to respond?
If you would like to.
Foremost, I apologize if the court takes that position. That is not my intention. It's a legitimate struggle for me.
And I'm not saying it's not. What I'm taking issue with is that you seem to suggest that you had already alerted the court that the struggles you purport to be having, you had already told the court about that, and that is not true at all.
And Judge, from my standpoint, it would be true from the standpoint of when we had the conference at the bench last court appearance, and I told the court that I did have this trial.
You told me you had a custody case. People have custody cases all the time.
Right.
That is not the same as saying what you are now saying.
I'm not sure what the difference is, Your Honor. But
well, to say I am having a mental condition that makes me unfit to represent anybody is not the same as, hey, I'm going through a custody dispute. And I don't mean to be blasting your business, but you're the one who's making that required.
That was the difficulty in communicating the last time. It's not something that I want to blast. I don't want my family on the media and all of this stuff. But I don't have much of a choice. Okay. I don't.
And I'm
so
sympathetic to that.
I'm sorry if it's not to your liking. I apologize.
What I'm trying to do is make sure that people who are on trial for murder have the representation that they need. And if this was actually going to be an issue, which it clearly is, this should have been brought to the court's attention well before now. You were told at the beginning of December that this case was going to trial in late February or early March. So this morning, at what is supposed to be the second pretrial conference, should not be the first time that you say to the court, you know what, I'm not in a state to be able to do this. Okay? So I'm going to grant your motion to withdraw. And with regard to what that means for the state, I think it's going to have to mean that Mr. McMullen's case is severed from this, because I'm not going to wait on the other two.
We didn't be quite frank with the court. This will be, so we're going to have three trials. I mean, I think it would be more beneficial and in the interest of justice and judicial economy to push the trial up another month or two.
Well, let me find out from GPDC what they can do in terms of representation, because Mr. McMullen, this is going to be his 5th set of attorneys, which nobody should have to deal with. That's not his fault. If they can get somebody in there quickly and we can get them up to speed, that's one thing. But I mean, he sat unrepresented for over a year. He went through 3 different sets of attorneys in rapid succession because of, I think, issues with GPDC. He's had this attorney since July, but this attorney is not able to continue. So I don't know. I'm going to have to hear from them.
And then I don't want to make light of Mr. McMullen's situation as it relates to his legal counsel, but I think it'd be relevant for the court to be made aware or be reminded that Mr. McMullen, he's serving a number of years in the Department of Corrections still. So his waiting for his counsel, which I can promise you all members of the state would help whichever counsel is assigned navigate through the discoveries for
Yes, I know, the state is bound and determined to proceed with the RICO count. So I'm aware that that's going to be presented in each one of these cases. But, I mean, they're otherwise, aside from that, he's facing one charge. That's murder. That's a serious charge.
Agreed.
And, you know, whether he is already in custody for other issues or not is not really what I meant. I meant nobody should have to go to court and face trial on a murder charge without an attorney who's prepared to try the case.
100%. I guess my point was, and I mean this in all due respect, that the state should be penalized for that as well, because we have limited resources,
I understand.
limited employees. A third trial would not be something that would be beneficial to anyone, but I would say it would definitely not be something that would.
I've just got to find out what our options are.
Yes, Your Honor.
Mr. Dark, can you, I know one of the issues that you said you faced when you first were appointed to represent Mr. McMullen was that you didn't have discovery. Now, you apparently didn't take any steps to get the discovery from the state, but you have the discovery now, correct?
Yes, Your Honor, I have the link and I also have a 8 terabyte.
Okay, let me ask you this. Can you, because I do not know yet who will take over Mr. McMullen's representation, can you just get the entirety of your file and bring it to the court, and I will hold it, I will not look at it, I will hold it so that whomever is ultimately appointed, I can give that to them and they can have the benefit of what you've done thus far?
Your Honor, yes, I can
Okay.
read the discovery and I can try to have it.
I mean, not just I mean, everything you've worked on,
Okay.
okay? I mean, your entire file.
Okay.
All right, I appreciate that. Is that something you can do? When can you get that to us?
I'll have to look through the file to see, like, you know, counsel impressions and notes and things like that.
Okay, I mean, you're welcome to put it in something sealed, but
Okay.
I mean, your attorney impressions and work product and what have you might be beneficial to Mr. McMullen's next attorney. I mean, yeah, I'd hate for he or she to have to start from square one if you've already gotten to square 25, you know?
Okay.
Okay. Does Mr. McMullen have any objection to that? No? Okay. All right, so can you get that to Chambers by like Wednesday of next week?
I can do that.
All right. If you will do an order, I will grant your motion to withdraw. And Mr. McMullen, I'll do my best to get other counsel lined up as soon as possible. But I mean, you know, because you've had attorneys in the case and then out of the case, in the case and then out of the case, that our public defender system is great. Our conflict defender system is pretty good. Our conflict after you move past the second appointed attorney in a case is sometimes a challenge because of a lot of reasons, one of which is probably we don't pay them enough, but it's just challenging to get attorneys who are capable and willing to take on complicated cases. So, Mr. Dark and Mr. McMullen have had some time to speak privately, and Mr. Dark, you had a potential proposal that might be a solution to our matter.
Yes, Your Honor. Our request would be that we sever Mr. McMullen from the main trial schedule and set his trial to begin for a time, June or after of this year. That would allow me the opportunity to be fully present and participate in the proceedings. I don't think it would disadvantage Mr. McMullen or even the state. When I've reviewed the evidence that I've seen thus far, Your Honor, his connection is very tenuous. He is charged with the RICO count. A lot of those things largely don't relate to Mr. McMullen at all. I think his connection stems from one main witness, and that witness would still be available. So I don't see the prejudice to the state, and also I see significant prejudice to the defendant by either requiring me to remain or even trying to line up someone new with the short amount of time. I think a trial would still probably be starting around that same time, but I think this would allow the court to proceed with the other two defendants.
This would allow the court to proceed with the other two defendants and respect all the rights with respect to Mr. McMullen as well.
Okay, well, I do think it would be a better idea if you feel like you'll be up to it once you get past your personal matter, your custody matter in April, to allow Mr. McMullen some continuity of counsel. You've been his attorney since July, and I think you're the only attorney who's been with him for any significant amount of time. And I know that you've been working on the case and you've gotten funds for experts and been pursuing that as well. So I would certainly rather you stay on the case, even if that means that it gets moved back a few months. One thing I would inquire about is if you believe you will be ready to try the case and fully present in, let's say, June. At that point, we're talking about, a 4-month delay. If we had to secure a new attorney for Mr. McMullen, we'd probably need to give him or her that much time or close to that much time to get ready anyway. I know the state has opposed severing Mr. McMullen out because it's a burden upon the state to have to try 2 cases instead of 1 when there is some at least alleged connection amongst these 3 remaining defendants. That mainly it appears being the RICO count, that is count 1. If we move the entire case to June, you would be ready for that as well, because really your client's facing the 2 charges, whether he's facing them in a sole trial or he's facing them in a trial where he's one of 3 defendants. Is that correct?
I think that would be accurate.
Okay.
I would ask if it's possible that the court appoint additional counsel for Mr. McMullen in the event to continue to prepare the case.
Like to assist you
Correct.
for the next little while?
Correct.
All right, Mr. Luwemba has graciously joined us, I assume as a representative of GPDC. I had reached out because Mr. Dark is an appointed C3 attorney. Mr. Luwemba, I know you are just kind of parachuting into this matter.
So Judge, Mr. Dark, we already spoke. He's gonna, if the court is so inclined to move the case back to June, Mr. Dark is gonna rescind his withdrawal, and he's gonna represent Mr. McMullen in June.
Okay.
If Mr. Dark is asking for an assistant to help him prepare for the case, that's something I can look into.
Okay.
To make sure that he does have an assistant, but he's still lead counsel.
Okay.
He's still going to be ready in June if this court is so inclined to move forward to grant his, because I know he has some issues, some personal things going on, to grant the continuance until June. So he will be there to represent him. And in between that time, Judge, within the next week or 10 days, I'll be in contact with you and Miss Rosser with that name, if anyone that we can get appointed to help assist him. Now, in all candor, that person that we get to assist him may be a paralegal. It may be somebody just to help do research or something. It may not be an attorney that files into the case.
Okay.
So that's also going to depend on, but I know he may need assistance with research, with kind of deciphering through the voluminous discovery. So I will try to get him those additional resources. So I don't want the court to look for another name to file into the case.
Sure.
That additional person may just be a really good paralegal that we can find and we can pay to help Mr. Dark throughout the process until June.
All right, I'm sure he'd be appreciative of whatever assistance you all are able to come up with. He's nodding in a sense, so that sounds good. If it is an attorney, great. If it's a really great paralegal, also great. So I appreciate you making sure that gets done.
Yes, Judge.
All right, so that'll be the plan. I know it's not ideal, but circumstances are sometimes beyond our control. So Mr. Luwemba, we'll wait to hear from you as to who that's going to be, and please let everybody know we appreciate the quick response. Well, he said a week to 10 days. So, all right. So thank you. So I'll excuse you, and we'll just wait to hear from you in a week to 10 days on who that's going to be. Thank you.
Great. Thank you, Judge.
All right.